Hello, everybody. Thank you for joining this podcast. I'm Stephen, representing our faculty's legal hackers. Along with me is Josh Morrison, who runs the Future of Law Lab, and our guest today, Samara Starkman. Samara is a partner at Inc. Law, where she concentrates on privacy, data governance, and health and tech law. She's also the managing partner at Inc. Consulting. So on behalf of the legal hackers, the Future of Law Lab, and everyone else here at U of T, thank you so much, Samara, for showing up today. I think this will be a great conversation, and I'm really looking forward to it.
Thanks for having me.
Great. So to get us started, I'd just love if you could introduce yourself, your area of practice, maybe like the kinds of clients that you're representing, the perspective that you're coming from there, just at a super high level.
Sure. So as you said, I'm Samara Starkman, and I'm a partner at Inc. Law and managing partner at Inc. Consulting. And I do practice in the area of privacy. A lot of my clients are in the public sector and healthcare, but also we focus on artificial intelligence. Private sector is definitely not outside of what we do, so I don't want to give that impression. It's just that the bulk of my practice tends to be in healthcare. But my partners certainly do a lot of work in the private sector and in AI and data governance and privacy, cyber. We help organizations get ready for new legislation, as we're going to talk about today, that would have been quite a heavy lift for some. We help organizations be ready in case there is a cyber breach, create their privacy programs, and share data with one another.
Awesome.
Stephen, I just wanted to bring up one interesting point. So, Samara, you mentioned that Inc. has a consulting wing as well. Mm-hmm. Do you find that that's kind of moved into your practice in a sense that, in addition to giving legal advice to your clients, it's very much from a business perspective these days?
Absolutely. A lot of privacy is very much about identifying risk in your business and making risk mitigation decisions that are right for your business. So you have the law, and then you have how do you embed that and comply, but in a way that is going to help you meet your business objectives. So you're never going to get zero risk, and it's always about risk mitigation. So we look at what are your business strategies, what are your priorities, and then how do you mitigate risk in that way. And so absolutely, Josh, we look at the consulting part of our business is very much focused on embedding into operational and strategic objectives.
So we're going to talk a little bit about Bill C-11, which, as you were mentioning, Samara, didn't quite come into fruition yet, but obviously a lot of interesting tidbits in there and things that may suggest where the government intended to go, where we may be going in the future. So first off, just from an overview level, what is your take on the current PIPEDA and its enforcement?
So PIPEDA is, a consent-based statute. The bulk of what we look at is in Schedule 1. It's very broad. I'm not sure that it fully meets our needs anymore as data becomes kind of currency and is so much a part of every business that we have that it doesn't necessarily, meet the needs of our new data economy. So I think from an enforcement perspective, there really isn't any teeth there, right? So, it really depends on people being willing to work with the OPC. And as we've seen with some quite large companies, that's not always the case. So there is a need, I think, for some amendment to PIPEDA that looks a little bit more at the reality that we're living in now as it pertains to data and people's understanding of technology and what is done with their data and how it's shared. And that has some teeth behind it as well, so that, there is incentive for organizations to want to comply.
Samara, what do you think about the role of the Office of the Privacy Commissioner? Do you think that that's a role that's being used effectively? Do you think that it's like the legislation that's maybe limiting the effectiveness of that role?
No, I think it kind of depends on what we're looking at as being the role of the Office of the Privacy Commissioner in order to really determine if it's effective. So, the regulator provides oversight and, guidance to organizations on how to comply with the legislation. I think that it's a little hard to comment on whether or not they're effective. I think they're doing what they can, frankly, from a, compliance perspective, but they really can't, they can do investigations, but again, they can enter into an agreement, to comply, but there really isn't a whole lot that they can do. So I think they're doing a good job at providing us with guidance, and trying to provide the oversight and that's needed for industry, really, and for individuals.
Great. So when you first saw C11, what were your first impressions?
So it is a complete rewrite of PIPEDA. It's not just an amendment. This is like, throw out everything and create a new one, but it's still consent-based. And consent is challenging when we don't always know what is going to happen with the data that we're collecting, and that it can be quite limiting to rely exclusively on consent. So it was a little bit, I think from my perspective, disappointing in that it isn't going in the same direction as a lot of international law. It certainly isn't going in the direction of GDPR, so which is more rights-based than it is consent-based. So when we think about, organizations being more stewards of data than they are owners of that data, I think it shifts things very much. And I've always thought also that it's very hard for us to consent to the use of data when we may not even really fully grasp all of the potential uses, as I said. But we could consent to how it's governed. And that isn't something that we see a lot. So how are decisions being made about data? That's really, the important thing here, not every single use, but in terms of principles, what are those principles and how are you making decisions about what's happening with my data? And then what are my rights in that data once you have it? So I think that consent-based piece is perhaps a little bit out of step with some of what's happening in the world internationally, and some of the, pieces of legislation that have really made a difference in the way that organizations operate, as GDPR definitely has.
Samara, do you mind, just for anyone listening to this podcast who's not familiar with what the GDPR is, could you just give like a really, really brief overview of what, in terms of, like, I guess you said rights-based, and maybe it's the pinnacle of what's currently out there already?
Yeah, so the GDPR is the General Data Protection Regulation. It's the European Union's broad-based privacy law. And it really has set the bar in terms of data protection. It came into effect, I want to say 2018, 2019, I can't remember exactly, but I think it was around then, 2018 probably. And it really puts a lot of onus on organizations to know what data they have. And it provides individuals with quite a lot of rights in terms of data portability and what they can and can't do, or what they can allow organizations to do. So the individual has a right to privacy. That is the fundamental basis of the General Data Protection Regulation. And organizations, I believe it's a little bit more of a stewardship model, where organizations are caring for the data that an individual has entrusted to them, as opposed to the individual having rights to data that isn't theirs, or that is no longer theirs because they've given consent for somebody else to collect it. So that's sort of where I see the difference a little bit in terms of the two pieces of legislation. And I should say, I don't do a ton of work with the GDPR, so it isn't my area of expertise, but it is certainly, something that has influenced every piece of legislation, and it does form a huge part of conversations as whenever we talk about privacy.
I was listening to another panel on privacy, and I heard the thought that the European Union is sort of leading the world with data privacy, and that all other jurisdictions are sort of following that model. I guess, to certain extents, some more than others. Is that the impression that you get as well, or?
Yeah, I mean, I think that businesses really reorganized in order to comply with the GDPR, and it has such strong penalties for non-compliance that imposing other obligations, I think, on organizations without the same type of penalties, and if they're unaligned, it's going to be such a burden on business that it really would just be not practical. At some point, we have to be looking at this in terms of businesses operate across borders, just almost by default at this point. Obviously not everyone does, but you have online, once you're online, anybody can buy your products, right? Anybody can tap into your services. You could be collecting from anyone, anywhere without really even realizing it. So I think that's probably right, that there is, because it has had such an impact that others are following suit. And then there's also been a lot of litigation in Europe around really, being able to do business in North America. And people want to be able to cross borders and be able to have, all of the rights that they have in Canada, they want to be able to have in Europe, and vice versa. In the United States, it's the same thing. There's always some apprehension about, storing data in the United States from Canadians, and now we have issues with whether or not there's adequacy. Sorry, I'll back up for a second. So in order to transfer data to the United States or to other countries outside of Europe, you do have to, the laws have to have been deemed to be adequately protective of the data. And that is a huge issue at the moment due to some litigation that has happened in the EU. So the more that we can align on, a set of principles in privacy, I think the better it will be for individuals and businesses, because it takes out that confusion, certainly, and really provides the basis for being able to have privacy, have, even consent, if we really wanted to go there. What does that look like? I should say, when I think about privacy, when we talk about what is that right to privacy, I think it's really important to know what we're talking about, and how is privacy actually defined. So when I think about privacy, it's not that data is completely secret and that it shouldn't be used and it shouldn't be out there and it shouldn't be free flowing. It's not any of those things. To me, privacy is the ability to choose where your data goes and doesn't go. And so it is, if we look at it in those, through that lens, I think that, it's the right to know what's happening with your data and to make choices about it. I think that the GDPR definitely, it isn't a perfect piece of legislation, certainly, but it does take steps towards those implementing those choices a lot more.
And so where would you say that you would spend most of your practice generally in terms of issues with PIPEDA?
So because a lot of my clients are either in the health sector or that they're technology companies that work within health technology, there's an interplay between the Ontario Personal Health Information Protection Act and PIPEDA as the private sector legislation. So private sector companies who do business with public sector healthcare companies still have to continue to comply with PIPEDA, but they have to enable their customers, healthcare organizations who are subject to the Healthcare Privacy Act, PHIPAA, to comply with that. So a lot of my PIPEDA work is on helping organizations to comply internally, making sure that they have privacy programs that are compliant, but also, align with best practices, and that they mitigate risk in accordance with all of these best practices, but also with their business objectives. And that they enable, if they are healthcare specific, that they enable their customers to comply with PHIPAA in Ontario. Outside of Ontario, on the consulting side of things, we can provide more advice around implementing privacy practices, that is non-legal advice. So when we're in other parts of the country, we provide some guidance around that as well. But here it really is about how do you have a privacy program that complies with one legislation, and how do you make sure that your clients can comply with a different piece of legislation while interacting with your business.
So, Samara, I think it makes sense because you have mentioned the difference between consent-based and rights-based, and there are exceptions to consent within C11. Were you bothered by that? Do you have any issue with that?
The part that is problematic is the knowledge and consent piece. So, making sure that there is knowledge in order to consent, that piece of it has been removed. So there is the onus on the organization to communicate, and it could be in a privacy policy, and as you rightly point out in your paper, it isn't necessarily something that people read or understand. And so, making sure that people do have that knowledge, to me, is important. And so from that perspective, I would be somewhat bothered, I guess. So what is valid consent is, I guess, the biggest piece here that is problematic to me. When it comes to, not needing consent to share between organizations for purposes that relate to the business, that is less problematic to me, just because people, organizations do need some ability to use data. I guess it just really comes into, what are they doing with that data? And does it kind of follow the same purpose for which it was collected, or is this a totally different purpose that the organization is benefiting from? And if there isn't a valid consent, then, or the valid consent has changed to not really include knowledge to the same extent, then I do think that would be problematic.
Do you think that the way it's currently worded, there's sort of an incentive for organizations maybe to organize their businesses in such a way that they can avoid getting consent entirely? Or do you think that's not too much of a concern?
I mean, I'm sure that's something that can happen, right? I mean, there's a lot of words that need interpretation, right? There's things that can mean, what is significant? There's a lot in this that could use a little bit more guidance, and whether or not that's from regulation or editing of the legislation if it were to go into a new come back in some way. But I do think that's a little bit would definitely be something that we would have organizations trying to do. Yeah, within the law, how do I not, where is it that I don't need to get consent? And that makes a lot of sense.
In respect of that interpretation piece, obviously there aren't that many privacy cases going through the courts these days. I'm wondering if you think with the tribunal, a lot of that interpretation maybe can be done, or how do you think that interpretation issue could get resolved better?
So that's a really good question. I think, what we see in PHIPAA is that the IPC, the Ontario Privacy Commissioner, does have adjudicators and administrative powers that are they're now much more reported than they used to be. So we have a lot of a lot more guidance in terms of why decisions are made or not made, just in that, kind of administrative law context. And I think that is quite helpful. And you see it as well in the context of freedom of information as well in Ontario. So I think there is, and it's more affordable as well, to be able to really use tribunals in that way. So I think there's potential. I think there's also potential to, make investigations and rationale for investigations public, which is done now as well. And then we also will be able to see, why was the decision made one way or the other, and how are these terms being interpreted. And so I think those are some useful tools if used, correctly, I guess, or with organizations in mind, in order to develop some consistency in terms of how organizations are complying.
And Josh, sorry, go ahead.
No, I thought, just based on what we were talking about, it was an interesting segue into whether or not, our overarching structure right now strikes the appropriate balance between commercial and privacy interests.
So I don't know that they have to be different. I think that it's often a dichotomy, or they're placed in contradiction to one another. And if you have more privacy interests, you're not going to have commercial interests. And I don't know that it has to be that way. So it's certainly not something that I think if we go into it thinking, if I'm too privacy protective, I'm going to negatively impact business, then we're not going to come to a place where business and privacy live harmoniously, and you don't sacrifice one for the other. So, maybe that's sort of like my optimistic privacy lawyer hat, but I do think that there is a place where they both live together, right? And I think part of what I've seen over the years is that we've shifted from, to a certain extent, where privacy is an impediment to my business. And if it's something I have to do, it's not something I want to do, to it being much more of a competitive advantage. So, 15 years ago, Apple was not talking about their privacy practices in their marketing material. There were some that were, but it wasn't Apple. It wasn't these massive companies. And so now I think people our businesses are starting to see that there is demand for it. And so if there is a commercial demand, then we're going to continue to see some of that change in the way that businesses operate. And I'm sort of going off on a tangent here, only to say that, I don't know that our legislation is necessarily going to be the one that strikes the balance. I think that, to the extent that we do look at something that is much more rights-based or principles-based, even, where we're looking at, these are the principles that you have to comply with, and show us how you comply with them. Keeping the individual in mind as that, owner, for lack of a better word, of their own data. I think to that extent that it allows for more innovation, it allows for businesses to be creative and still continue to respect the rights of individuals. And I think that's really what we're trying to get to here, is not developing legislation that will stifle businesses' ability to innovate. We don't want people innovating around how to get around legislation. That's certainly not, where we want people to spend their time, but where it's, individuals have a right to their data. So how do you build that into your technology? And, building, I think there's an entire industry that's built on privacy protective technologies now that didn't exist 10, 15 years ago. So, there is, I think we do have to be careful in legislation around how do we make sure that it is not stifling business, because we can, if we're really directive and impractical, right? But where we can create some principles and values that businesses have to live by, and demonstrate that accountability, but allow them to figure out how they're going to do it. I think that in those situations, we can have an incredibly protective privacy regime with not impeding commercial activity in any way. So I think that's, we want people to be thinking about privacy. I think ultimately that's really where we're headed, but not to the detriment of their business either.
Well, and I love the comment that you brought up earlier about that we have this false dichotomy of, it's always going to be competing, like the corporate interest versus the privacy interest. And like you said, there's marketing opportunities. There's entire market segments built around, going after customers on the basis that privacy is important to them. So why wouldn't I make it a part of my business as well? So I think you're right in that regard, that maybe they're more aligned than we would think off the top of our heads.
Yeah, I mean, I think when we talk about balancing the two, then we're starting from the assumption that they're contradictory, and I don't think that they have to be.
Do you think that there's some disambiguation, I guess, that's needed for looking at different businesses that have different business models and respective data? When we're making these laws and we're thinking about businesses, like obviously businesses are entirely different and some of them have very data focused business models. So how do you think we should think about these businesses differently?
I look to some of what we have in healthcare, and early in my career, in my privacy career, I led the privacy department at Cancer Care Ontario, and Cancer Care Ontario is a prescribed entity and prescribed person, or under PHIPAA, which allows them to collect data without consent. So, and they have specific purposes that they have to use it, or that they're permitted to use it for, and there's rules around it. There's also a guide that was given and never changed about what their privacy program has to look at. And it's very specific and very directive. And so, my experience with that is, really realizing that type of directive doesn't work for everyone. It isn't something that allows businesses to create what they will need to create to operate and still be privacy protective. So even, within that context, the minute detail that needed compliance really became a checklist of what you just needed to have in a policy, as opposed to what are you doing like in real life to protect data. And so I think it's important that how we look at businesses is open enough that they can do what they need to do to operate while protecting data. And so any sort of legislation needs to consider that and not be too directive around how, but more around the demonstration of it and making sure that those businesses have accountability and decision-making processes and data governance in place, so that at least the decisions that are being made with principles. They're being made, thoughtfully. What data is there. Individuals have rights to their data, and that these are things that are transparent as well. So even if you're a Facebook or Apple, yeah, both of them have data. And I guess, arguably they're both data companies. I think, ultimately when it comes down to it, you mentioned this in your question too, every company is collecting data. It is just a matter of size. And so I think if you do get too prescriptive, the little companies can't comply. And the bigger companies, doesn't make sense for them to do it in the way that is being prescribed by, an outside party. So I always go back to it just really being about principles, decision-making, data governance being, a very important piece of this, and individuals being able to understand how decisions are made about their data.
So I guess relating to that, do you think that C11 may go too far with maybe with respect to like small businesses, at least, in how much it demands of them?
Um, I don't know. You know, I think it's arguable that it does, and at the same time doesn't go far enough, right? So when we go back to what is it that what do they have to do? Is it significantly different from what they're doing now? And you know, I'm not totally sure that small businesses would, or you know, unless there is that fear of the penalties that are within this bill, that you're going to have this wholesale change. I mean, you're not going to have anything with this bill because it died on the order paper, but you know, in that the next iteration, you know, I do think that it is important to keep in mind what is entailed and how does that align, as we started our conversation, how does that align with international expectations? Because we want our businesses to be competitive internationally as well.
So I think that'd be a great segue to talking about the enforcement of C11. So what are your takes on the teeth that we've got now, or that we could have if that were?
I think that any legislation will need to have, you know, some financial penalties. What I would love to see as well is some kind of, you know, quality improvement piece where businesses are encouraged to share data, but in a privacy protective way, and where they need help, that they are actually able to get it. And if there is, you know, that we don't just go right to penalties, because sometimes penalties themselves can be a deterrent to the data sharing piece that needs to happen as well. So we want to, again, like, there is a balance there between what you know, penalizing and then also deterring positive activity. So I think the enforcement, I mean, we do need to have large penalties. I think we need to have some sort of like more teeth for the OPC, but there's probably some areas that you know, can be improved in the next iteration, certainly. But again, like, I would love there to be a way for organizations to like a scale, right? And it isn't, you know, not all breaches are created equal, and you know, legislation that recognizes that is also important.
Do you think there's anything that C11 does particularly well, or?
Well, honestly, yeah, what does it do particularly well? I think yeah, we've been talking about all of kind of the issues with it. I think that it does have some data rights for individuals, like portability. You know, I think there is that recognition within the legislation that an individual may need to have that option. And it's interesting because we have just seen with the pandemic data portability in action, right? Like, your phone is where you would carry your vaccine passport, right? And it was up to the individual to decide whether or not they were sharing that or not. You know, I mean, there were consequences if you didn't, but you were really the one who was in control of where your data went. And so it'll be interesting to see when we do get some sort of legislation in place where data portability is embedded, whether or not we learn from how that was implemented, because it is completely different than how we normally talk about sharing information, right? We always talk about it being shared between organizations or shared between healthcare providers, but it isn't in the hands of the individual. And so I think it'll be interesting to see what legislation, what the world sort of looks like with our change in technology, our individuals really being all over now. There's so much remote work that having the ability to have data portability becomes even more important, because you can be seeking services, you can be seeking care, you can seek so many different things in different locations because everything is virtual. There's a time we would have been doing this in person, not that long ago, right, where I'd come down to U of T and we'd sit around a table and there would be a microphone, and that's really how we would have this conversation. It might not have occurred to us to do this on Zoom. So I think things are changing so rapidly and unpredictably. I do think that data portability, it's not a right per se in the legislation, but it certainly is something that is included and becomes an important piece as technology changes and as our mobility changes as well.
So, and you sort of mentioned this a little bit, but how do you think that privacy just as an area of law is changing, particularly in respect to the pandemic? I know you mentioned a couple issues there. It seems like a bit of a growing field to me, but from a practitioner's perspective, what's your take on that?
Definitely growing. When I started doing this years ago, 10 years ago, it wasn't really a thing. It was like an annoying thing. I have to deal with privacy. And now that's being sought out, it's being considered, people are actually thinking about it as part of their business, and they embed it into their business if they're, smart. If you're forward thinking and building a new business, or even, revising what you're doing with data, and people are becoming much more aware of the risk involved with collecting, using, disclosing large amounts of data. And so it's definitely a growing field. I think, individuals are waking up to how much data we give out. And as we talked about, they're starting to demand much more of it. But on the flip side, I'm also seeing that people are so used to breaches that it almost has no, almost has no meaning. It definitely has meaning, but there's almost a complacency now when you do hear, oh, another breach happened. Okay, so my data's out there. Now what? And I don't think that we've fully realized, I certainly haven't, what all the potential uses and consequences are of all of that personal data being kind of out there. So there are certainly people who are thinking of all of the ways that data can be used, and we have to get ahead of that. But it is nice to see the shift in businesses to understanding that the data is, if it's valuable to them, it's valuable to others, and how to protect the data, I guess, and I always try not to say data protection, because what are we protecting data from? We're not protecting the data, we're protecting the humans, right? Whose data it is. And again, we go back to, what's your definition of privacy? And definition of privacy is about individual control. Then is it about data protection? Or is it really about something else, and humans having that right to make decisions? So I hesitate when I say data protection, because this is really much more about, a human right to make decisions and to be self-actualizing.
And Stephen, I don't want to take us off track and blow up any train of thought that you had, but I think just based on what Samara was saying, and also the fact that, we call ourselves the Future of Law Lab, and we're always forward thinking about what's coming down the pipeline. It's kind of like the perfect segue into the final topic area of, what's next? What's coming? What does the regulatory future of privacy look like in Canada? Are we going to zombify Bill C-11 and bring it back? Are we going to look to, take on aspects of the GDPR? Or is there even an appetite in Canada to become the leaders in privacy in the world?
It's hard to know, from what the appetite is at the federal level for, but I think Bill C-11 has given us some insight into what the next iteration of a privacy law might look like. With a minority liberal government, I don't know if we're going to see, Bill C-11 in some form being brought back. And if it is, what form that might take, because, well, who knows? So, but I do think we're seeing some pieces being taken from legislation in other jurisdictions, right? We're seeing the portability, we're seeing the right to be forgotten, the algorithmic, the explainability of algorithms that make decisions on behalf of, or instead of individuals. We're seeing, I think we'll see some sort of financial fines that are larger than they are now. Certainly, I think we're going to see, I think we're going to continue to see a consent-based statute, but that could change also. I think it really, there's that piece of it I'm really not sure about, but I do think we're going to see more in terms of a tribunal. And we can look to some of the other legislation that's coming out in other jurisdictions, even in Canada. There's so many jurisdictions right now that are looking at their privacy legislation. Even on Ontario, we're looking at, is there going to be a new private sector legislation? So I think we're seeing where there may be gaps in what is viewed from a federal level or in PIPEDA to provinces stepping up and taking ownership of those pieces. So I think we'll continue to see more provincial privacy laws before we see a wholesale change in PIPEDA.
And then from a very theoretical point of view, what sort of framework for privacy interests do you think is a right one? And you've touched on this in a lot of different ways earlier in the conversation, but like, is consent the right approach? Is maybe like a liability framework one? I know, like, I can really like relate to your discussion on people just don't know like what they're really signing on to when they give their data away in a lot of ways, and they can't know for a lot of reasons, right? So how do we best protect this data?
That's a good question. And I don't know that I have the answer at all, in terms of what's the best framework. I think there are people who spend their careers just thinking about this, right? And so I definitely leave that to those experts. I do think about what the considerations might be within those frameworks, right? And we've talked about some of those today. So knowledge is important. The individual understanding what it is that's happening. So is that in the basis of consent or something else? I don't know, but understanding what's happening with your own data, I think that's an important piece that we would want to include. And all of this, as I've said, comes from my belief that privacy is about choice. And so when you start there, I think any policy decisions that follow would be a helpful way of looking at privacy from my perspective. And I think we need to also think about making sure that we are technology agnostic, because who knows where technology is going to go, that there's transparency in terms of decision making, not only by businesses using data, but by the regulator in understanding why decisions are being made in different ways, and how those decisions will be overseen and what consequences there might be. So, and I think I also mentioned there just being like a scale and supporting businesses in getting better, as opposed to just punishing them for making a mistake or anything like that.
And if there's one or two things that we could import from the GDPR that maybe weren't contemplated in C-11, perhaps stronger data portability, I know you focused on, what might those look like? Or even GDPR aside, what do you think's missing in C-11?
I think probably we want to look at children and minors and how their consent is dealt with, and what can be done with children's data. We don't see that. Just thinking, what else is missing from there? We don't see political parties being covered. So there's specific groups. Employees are another group that is a gap in our legislation currently. And I don't remember if C11 has employees in it, but I do. Do you know?
I don't remember reading anything.
Yeah, I
specifically
don't
about
remember
employees.
reading about employees. So, but I'm hazy on it. But we don't have employee protection and privacy legislation right now. It is a gap unless you're a federal employee. So that's covered. But those are some of the gaps that I see, is like we need to really deal with political parties, employees, and definitely minors.
Yeah, and employees, like I'm just thinking about like with respect to COVID, and I think I've heard a bunch of issues relating to like businesses increasingly tracking inside, employees' own homes, exactly what they're up to, and like even surreptitiously in some cases. I'm wondering if you've heard about that or what your impressions are on that sort of stuff.
Yeah, definitely. And there's been some amendments made to employment legislation. And I am not an expert in employment legislation, but there definitely has been some amendments made to those pieces of legislation. So where we see things like surveillance, you have to have, if you are a business with more than 25 employees, they have to have a policy on it. You need to, have a policy about the right to disconnect, which has also become an issue during COVID, where we're, constantly online and connected. So a few different things have happened there. But the surveillance one being kind of the more privacy related one. But we haven't seen, just general employment information that's collected, right? So as a private business can definitely collects your social insurance number, and it will have all kinds of other information that's private to you, personal to you, and there's common law, and there's arbitration and that sort of thing in the unionized context, but we don't have it within our current private sector privacy legislation, how employment data needs to be dealt with in Ontario.
Samara, I know we've already taken up a lot of your time and gone over on the time that I suggested originally, but do you have time for one last wrap-up question?
Yeah, for sure.
Okay, Stephen, do you want to throw one last one out there?
Maybe just for up and coming U of T graduates who may be interested in entering privacy law, do you have any tips, tricks, or insight for those people?
I think it's fabulous if people are actually thinking about privacy law now, because that certainly was not something on anyone's mind when I graduated from law school. So it is a growing field. There's so many opportunities, I think, within this field. There's definitely not enough people in it to meet the demand. We're seeing much more, as we've talked about, legislation that requires DPOs and data protection officers. So go for it would be my recommendation. Be willing to, be open and learn and start at the bottom, because operational experience is the most valuable when it comes to privacy. Like the law is a piece of it, but you really have to know how it's implemented in order to be helpful to your clients. And so go to conferences, listen to people, learn about it, get your certifications, show that you're interested in the subject matter if you want to get into it. And I guess this just applies for anything, but a lot of the privacy jobs are looking for people who have experience. And that's a problem, right? Because people are so busy right now that they just want people to come into the roles and have experience. And that's a problem for people who are just graduating. So, however much you can learn and bring to the table will help to open doors initially. And then hopefully we can get to a point where people are feeling like, okay, I can actually train people right now. But, I think there is definitely there's definitely a need, and it is a growing field, and we get to work with some incredibly interesting topics and companies that are doing incredible things that we never would have thought of before. So that's one of my favorite things, is working with these innovative companies who are developing new technologies and new business models that I have never would have considered, and learning about them. And that is something you really get to dive into when you're working in privacy. So I definitely recommend it. And that's kind of it.
Well,
Fantastic.
Yeah, go ahead, Stephen. Take us out on this one.
Sure. Well, yeah, thank you so much, Samara, for joining us today. Apologies for taking so much of your time. Me and all the students working under me had a great time researching all this. It's obviously super novel, super interesting issues going on in the privacy space. And we really appreciate your perspective on all these issues. So thank you so much on behalf of everyone here at U of T.
My pleasure.